Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And today we're going to focus in on the opening arguments of the Stanford trial against the Stanford victims trial against the Office of Financial Institutions, or OFI. And if you will recall correctly, we had left off on the last segment by indicating that the attorneys had been arguing pretty extensively about the level of threshold that would have to be met by the Stanford victims for culpability on the part of the OFI. And the OFI attorneys were arguing that it should be gross negligence, whereas the plaintiff's attorneys were arguing willful indifference or recklessness. And so the judge had indicated he wanted both attorneys, or each side, to draft their ideal instructions for the portion that they could not agree upon, and that he would make his decision the next morning, which was Thursday morning. When arguments began, and bear in mind the jury has not been present to see any of all of this. None of the Gary Newport stuff that I mentioned to you that had happened on Wednesday. The jury's never been present for any of this, okay? So we've still not reached the point of opening arguments where the jury is actually seated and hearing the real deal, if you will. So still the jury is not present. Mr. Price, who is the lead attorney, his daughter Carolyn Graham is the other attorney representing the plaintiffs. He started out the Thursday morning saying, "Your Honor, I was kind of in disbelief that the OFI would even state that they had no duty to warn." He said, it literally blows me away. At any rate, Judge Johnson, they had presented their two sides. Judge Johnson went into chambers, and after an extensive amount of time, he came out and he ruled, as far as the jury instructions, he ruled in favor of the plaintiffs. Obviously that wasn't real pleasing to OFI attorneys, and so I wrote down at 9:15 a.m. They asked for Judge Johnson to submit the Word document with the jury instructions so that they could file a writ application with the First Circuit. I had indicated that it was a potential chance that whoever lost this argument may seek to appeal, because then that should show you how important it is. Gross negligence is a very high bar to have to clear, and obviously the OFI attorneys want that to be the bar that would have to be cleared. So after that, Judge Johnson read the preliminary instructions, and that's 18 pages, and he is a very slow and methodical reader, so that took quite a while, and he did emphasize that there's a chance that these preliminary instructions may differ from the final jury instructions. Obviously the jury does not know that the instructions they've just been read, at least a segment of them, are being appealed even as he was reading them to them. So with that, hey, opening arguments finally began on Thursday. And Carolyn Graham, again, that's Phil Price's daughter, she began by saying that there were 900 plus clients that on February the 17th of 2009, they learned from the news that their retirement savings, in many instances a significant amount, were literally worthless. And she even referenced a 70-year-old who had to literally return to the workforce. And she said this whole trial is going to center around what OFI knew and when they knew it. And with regard to her, the reference to the 70-year-old having to return to the workforce, I vividly remember a Exxon worker on a television news story that said he didn't know what he was going to do because his savings was completely wiped out. And his wife expressed concern because he had taken an offshore drilling job. And that's a tough job for somebody in their 20s. or 30s. So, you know, here's a 70-year-old man, and I'm not saying it was this particular character, but I do remember this, that was going to go and literally work offshore. This give you an idea of the devastation that these folks endured. She said that Stanford Trust was chartered in 1998 and that Baton Rouge was basically the epicenter of the fraud. And Mr. Price began arguments in saying that Mr. Stanford was receiving kickbacks to basically make this company appear as if it was the, you know, impression of success. And look, I want to say one thing. You got to realize I live here in Baton Rouge, so it's not like I have to wonder what all went on here. Alan Stanford would sponsor LSU basketball games. It would be this big signage out there. He was on CNBC being interviewed as what did it feel like to be a billionaire. And so he had taken in a wide net of the impression of success. And Mr. Price is indicating that that was all from kickbacks to finance his lavish lifestyle and create the impression that he had a highly successful operation. And he contended that the OFI knew that there was being money funneled into the Bank of, and I learned from the defense attorney, it's apparently pronounced Antigua, not Antigua, because I was doing the same pronunciation. Mr. Price argued that the OFI knew that there was no valuation for these certificates of deposits, and he used a fairly simplistic analogy, which he showed by PowerPoint. He used a funnel, and he would show the money funneling in. I don't have a funnel, but just imagine one funneling in from these investors, and then it goes down the little spout and out, and it shows it going out to the bank in Antigua. Mr. Price stressed that January, let's see, I wrote down January 1st of 2007, and I guess that's the right date. I know it was 2007, but I thought maybe it was January 7th. But at any rate, whether it be January 1 of 2007 or January 7 of 2007, Mr. Price is indicating that's going to be a very, very, very important date, because he is stating that if the OFI had done what it should have done, then none of his clients would have ended up purchasing the CDs that they purchased. In other words, all of his clients purchased CDs after, we'll just go with January 1st, 2007. That is the crux of the arguments from the plaintiffs in terms of the opening arguments. I want to shift now to the defense opening arguments. And those were led by Mr. Dennis Blunt with Phelps Dunbar. We'll see if we can't give you links for each of the attorneys that were involved to this point in the trial so that you can get a better feel of who's who. But that was led by Dennis Blunt. And he said, notice how when Mr. Price did all of this discussion, he never mentioned two words to you. And he said those two words are Ponzi scheme. He said those words never came out of his mouth. And he said basically what's going on here is OFI is just the last man standing. I put that in quotes. It's just the last man standing. And he stressed the fact that there were operations going on in Texas, in Houston, and so forth, but OFI only has jurisdiction over state chartered institutions, and he basically argued that oh yeah, y'all have to forgive me. My handwriting is not always the best. He said, and just imagine this, This bank in Antigua can allow these investors to magically outperform all U.S. bank CD rates. Does it sound a little bit too good to be true? Let me just say this. That's, I think, a very effective argument. And as most of you know, my mom recently passed away about 3 years ago. And she had a friend, and she's still alive. Her friend is almost 97 years old. But when all of this was breaking, I remember we had lunch together once, all the three of us, and you have to realize this lady is very strongly opinionated. And when I say opinionated, I mean opinionated. And she got on this topic of the Stanford situation, and you have to realize, I just told you she's 97. Well, even back then she was, early 80s. And so she would drive. I'm laughing, and she won't see this video, but I'm sure she'd say, go ahead and laugh. But she would take out CDs at local banks, and when one would come up for renewal, she would look at what the highest rate she could get up to the insured limit, and she would drive to this bank, that bank, or the other bank, whatever one she could get, because you got to realize rates were fairly low, and they got even lower before everything was said and done. But so at any rate, she's driving from one bank to the other to try and squeeze out a little quarter of a point if she could manage. And so she said, I'm going to be blunt with you. I don't think these investors should get a dime. And she said, if this is all worked out and they got those returns, were they going to share that money with us? No, but here we are being expected to bail them out. So those who are close friends of mine are going to know who I'm talking about. But she's a good lady, but she is very strongly opinionated. I had to throw that in because that goes to the point of what Mr. Blunt was saying. Some alarm bell ought to go off that, okay, if I'm earning 7.5 and the next biggest competitor in the Baton Rouge area is 4 or 4.5, is it too good to be true? And he did a good job of impressing that point. And another point that Mr. Blunt made was that the OFI basically, again, stressing that it's a Ponzi scheme. He said that, try to make sure I get this right. I believe it was June the 8th, but I'm looking for that. Yeah, June the 5th of 2008. I wrote down so many dates that sometimes they overlap. He says, Mr. Price says you should fixate only on January 1st, 2007. But I, being Mr. Blunt, believe that you really need to focus in on June the 5th, 2008, because he said it was that point at which the OFI was basically invited to a meeting in Fort Worth, Texas, and that involved the FBI, the U.S. Attorney's Office, FBI, the U.S. Attorney's Office, and the OFI was invited, and he said that's when it got revealed that what we've got here is a Ponzi scheme, or it looks like we're having a Ponzi scheme, and he is saying that that's when the OFI first got knowledge of it. Now, I wrote down the date June 4, 2012, but I'm not sure. I'm sorry. Now I know what that date is. He also said there are plenty of other folks that went to prison besides Robert Allen Stanford. I could rattle them off. Laura Pendergraft's 36 months. All of these are for obstructing the obstructing the SEC investigation into the Ponzi scheme. Laura Pendergraft's 36 months. Someone else 20 years. Another person 20 years. And so he's saying to portray that the OFI would have had the authority to single-handedly go in and nip this thing in the bud is just not accurate. And I do want to say this, he's right in that regard. Like I said, I'm going to try to maintain as much objectivity as I can in this. The OFI, and by the way, we talked about the Gary Newport situation. Well, Gary Newport testified that John Ducrest basically attempted to get him fired, and he basically said the OFI is a political animal. I think the plaintiff's attorneys were glad to get that on the record. Remember, the jury wasn't present for that. But look, I can just tell you right now, we can all stipulate to the OFI being a political animal. Look, I was with the FDIC and observed these things, and some of the things I could tell you are unreal. But for one quick example, Larry Murray was the commissioner during the time that I was with the FDIC, and he spent literally so little time in that office that one time he came in to speak with one of his staffers, and the receptionist, when he came and said, look, I need to speak with so-and-so, and she said, well, no, sir, do you have an appointment? And he looked at her and he said, I am the commissioner of financial institutions. And she said, well, I need to know if you have an appointment. And we all busted out laughing, but my point in that is that it is a political animal, no question about it. So to the degree that that was viewed as a significant revelation, it's not a very significant revelation to any of us who know much about the OFI. That's all I can say. I'll tell you one other quick thing. When I was with the FDIC, whenever you have a strong suspicion of criminal activity, when you uncover such as an examiner, as FDIC, we don't have any ability to prosecute that, but what you do is you prepare what's called a criminal referral, and then you submit with all of the documentation to back up your contention that criminal activity is going on, and you submit that criminal referral to the FBI. And we had done so for a bank that, for all intents and purposes, operated out of Hammond, even though its headquarters was Amite and then later was moved to Lacombe. And I don't know how, but somehow the OFI managed to inadvertently mail a copy of that criminal referral to the subject. It was supposedly an error. It's the epitome of sloppiness if you want to say it was an error. I don't think it was an error, but I'll let it go at that. At any rate, Mr. Blunt stressed the fact that there were billions of dollars that were being processed through from Texas and Canada that the OFI has no regulation whatsoever over. And I told you about him stressing that these investors would have their CDs just magically outperform every other bank in the nation. And talk to you about 6/5 of 08, the Ponzi scheme being learned about by OFI. Now obviously Mr. Price, he didn't say Ponzi scheme. Mr. Blunt is correct on that, but Mr. Price is arguing that these work papers that the Supreme Court has been gracious enough to allow us to see is going to demonstrate that the OFI knew, and using his words, was willfully indifferent and didn't provide any kind of attempt to bar these things from being sold. The one thing that I will say, I remember, because I've stayed glued to this, I remember early on accounts of this, and I distinctly remember it being said that there was the FDIC emblem implicit saying that these things were insured. If that is true, it sure would have been nice for somebody to have dropped a dime on the FDIC, because I feel like they would have certainly said, look, you cannot go out here inferring that these things are FDIC insured. What people were apparently being told is that well, it's insured through a mechanism called FDIC excess. The excess meaning, obviously, the amount of these CDs were way over the limit that the FDIC would provide coverage for. So it is a little distressing, and I don't know if we're going to see that in this trial or not, but it is distressing to me as a former examiner to know that someone would have stooped to the level of providing that little emblem to portray that these things were FDIC insured when they most certainly were not. I'm going to skip over a little bit because I don't want this thing to be too long. But I will stress that Mr. Blunt made an excellent point in the tremendous resources and the tremendous power of federal regulatory authorities versus state regulatory authorities, and he is dead on accurate on that. And so his point basically was that, look, the true regulator of securities sales is the SEC. And he's right on that. Furthermore, he attacked Mr. Price's statements about the valuation of the CDs. He says, well, you know, if you're believing that it's a CD and it's insured, well, the value of it's going to be its face value. So, you know, the argument about what's the market value of these CDs, well, unless something bad wrong, it ought to be its face value. So those were other good arguments that Mr. Blunt made, and overall, I think you got to realize he and all of the defense attorneys, they're in the unfortunate position of having to defend us as taxpayers for a situation that is just horrendous in people having been defrauded. But he has a job to do, so do all of them as defense attorneys. And in the opening arguments, I believe that he did a very admirable job. He also stressed to the jury that in order to even be allowed to participate in this, you had to be known as what is known as an accredited investor. And he stressed the fact that is, you have to have a net worth, excluding your home, of at least $1 million, or have an income of over $200,000 if you're single and over $300,000 if you are married. And his point in that is that there's an implicit assumption that you're sophisticated to have amassed that sort of thing, and that I guess that you wouldn't, I don't know the right words to use, because what transpired here is just god-awful, but it's a theory that this was not an old lady with the last dime of savings. That these were people of substantial wealth. And he said that nobody complained. Nobody filed an SEC complaint. Everybody was happy until the financial crisis hit, which is when all of this blew up. And I want to go back to Mr. Blunt's point about the SEC. The SEC being the federal regulatory authority over the securities. That is certainly true. But don't get any false sense of comfort from that, because I'm just here to tell you that there were some young staffers that went in trying to argue with the top brass at the SEC that the Madoff situation was a fraud, and they had the demonstrative proof to demonstrate it. Specifically, they would say that, look, you're looking at, he's alleging that there were more contracts, either puts or calls, that were traded that he bought that day. That's more than the entire volume for that day. It's even more than the open interest that existed at the opening of the market. So common sense, it's got to be fraud. But all I can tell you is the top brass at SEC, you know, is how dare you come in and accuse a distinguished gentleman like Bernie Madoff of fraud. You have to realize Bernie Madoff was the former chairman of the NASDAQ stock exchange. And so it was just, you young squirts, you know, you must be out of your mind. Turns out they were anything but out of their mind. But I said that to make that point. And I want to just say one other quick thing to elaborate on what I had said in the first segment. As I said, there was considerable anguish over the fact that the Madoff victims did receive $500,000 in SIPC insurance coverage. That's Securities Investors Protection Corporation. And the Stanford victims got zero. And I briefly told you that the reason for that is that SIPC insurance is designed to ensure the existence of securities. Whenever you have a account at a Merrill Lynch or Charles Schwab or whatever, and they're holding these securities, those securities are in what's called street name. In other words, they are in the name of that brokerage firm and they're allocated to you. Merrill Lynch may have, you know, 85,000 customers who, and I'm just putting a number out of the air, who have shares in IBM. Well, if a brokerage gets in trouble, what the SIPC insurance is designed to cover is that if they said, whoa, we're having trouble keeping things afloat, we're having trouble keeping the doors open, we'll just sell some of his stock. After all, it's in our names, not in his name. And so those shares, they aren't, the shares that you thought you had aren't there. And that's exactly what happened in the Madoff situation. It was clear cut in the Madoff situation that these folks were entitled to $500,000 because the securities that were purported to be theirs weren't there. He was manufacturing statements to give the illusion that they were there, but they're not. Whereas on the Stanford situation, you had a certificate of deposit, okay? And you could take possession of your certificate of deposit. That security's still there, all right? Now, its valuation is a whole other matter, but the SIPC is not going to ensure the valuation of any stock because they collapse, you know, right and left. Ideas work, ideas don't work. And they're not there to bail it out when it doesn't work. These securities turned out to be worthless, but that didn't change the fact they existed and these investors had them. So I know that's not an easy thing to have to take as an investor in this, and you see in these other group getting 500,000. And I mentioned to you that the SIPC, and in my opinion, they made a grave error in doing this, but what they tried to do, there was a lot of political pressure. David Vitter was doing everything he could to try to get these Stanford investors some relief from the SIPC. And so to try to keep peace and harmony in the family, which I still believe is a mistake, you just don't, you open up Pandora's box, in my opinion, when you do this sort of thing. They had agreed to give each victim $250,000. Up to $250,000. Obviously, if your loss was less than that, you'd get less. And it just, there was the infighting, some saying, no, no, no. We want the whole $500,000. And so the SIPC warned the investors that you're basically being a fool if you turn this down, because when we go to court, you're going to lose. And they said, fine, we'll take our chances. And so they went to court, and as could be predicted, it was ruled that the SIPC does not provide coverage for this sort of thing. In hindsight, I'm sure many of them wish that that $250,000 was still available. So let me move on, and then we'll wrap this up, because I don't like to spend a lot of time on what we're about to, because it's just heartbreaking to start seeing these victims get up on the stand, and you're not in the courtroom to see what is having to be seen in terms of the age of these victims and their physical abilities. I mean, just think about it. They're not young. So I'm gonna just cover the first two witnesses, and then we're gonna call it a wrap. The first plaintiff witness was Kathleen Ann Sonnier Neer. She had been an algebra teacher for 28 years, and she had approximately $74,000 invested. Her husband, who is now deceased, she said he had an investment as well. And she said, and they found out about this whole thing on the TV news. And she said that they had a supper club that apparently talked about investments and whatnot. And she said she felt so ashamed and humiliated. And she said, and they would show up at the supper club, and Stanford was all the talk, and she didn't want to say, I'm one of those victims. So she said she called a friend to ask that they please not talk about Stanford in future meetings. I will say this: she indicated that she got lured into this through her local bank, Bank of Zachary, and a gentleman that was sectioned off that would provide these securities, in whom she had the utmost of trust and faith. And you can never be overly trustful of any financial advisor, but I want to again state one thing. When the FDIC allowed this sort of thing to go on, that a bank could sell these type products, it was absolutely clear that had to be sectioned off, and there had to be the warning that this is not FDIC insured. And I would hope that there was prominently on display that disclosure before Ms. Neer unfortunately wrote the check. The second witness was a gentleman named Fred DeMorris, and his financial advisor was Jason Green. Jason Green was a former broker at Merrill Lynch, who had a daily show on WJBO, giving general advice, and he was a very well-known name in Baton Rouge. And Mr. DeMorris said that he had the utmost faith and confidence in him, and so when his Exxon retirement came about, he said he opted for a lump sum versus what I think may have been a potential of having an annuitized deal. But at any rate, in my notes it says it was $817,000, and that was actually put up on the screen, so I actually was able to get close enough to see that. But he said everything got frozen. When this whole thing collapsed, everything got frozen, and he said we went from thinking we were well off and comfortable to having to take out a second mortgage and trying to figure out how to. He said the receiver froze everything, even a little 15,000 IRA. I believe it's a 15. Yeah, I think so. No, he took out the second mortgage because he said we had to have funds to just meet daily expenses. So, like I said, I understand the only thing that happened Friday was some more victim testimony, and if that's the case, Monday I will be there tomorrow morning. I'll take some general notes, but it's tough it's really tough to sit through that sort of thing. So That will bring you up to speed for where things are at this point in the Stanford fraud victim suit against the OFI. I want to thank everyone. I know this one ran a little bit longer than I try to make these, but you got a lot of material crammed into this little over 30-minute segment. So thank you once again for your dedication, and we look forward to bringing you segment 3 of this trial of the Stanford victims versus the OFI. Thank you once again.